My name is Nadia Khadem. As more people have access to the internet, our lives are becoming increasingly reliant on technology for creating, exchanging and sharing our information, ideas, pictures and videos. Twitter, Facebook and YouTube are seen as essential communication media, and many people are reliant on such platforms to carry out their day-to-day activities. I am certainly guilty of this. What is often not properly considered is the size of the virtual community receiving our information, the immediacy, and most importantly, the permanence of that communication. My chosen area for research is the right to be forgotten, and specifically whether the ECJ's decision in the case of Google Spain and Google Inc. and AEPD Mario Costejo Gonzalez was reasonable, or whether it was a complete disaster. I chose this area as it is very current and I find it extremely interesting. Not only does it involve a revolutionary ECJ decision, but that decision was debated by the House of Lords and there are huge ramifications in terms of compliance and enforcement. The subject relates so closely to my generation and the worries we have about what information is out there about each of us. The Google Spain case involved a complaint against a Spanish newspaper that a Google search on the complainant's name brought up a historical and now irrelevant notice indicating that he had had his home repossessed many years before and that this infringed his privacy rights. The ECJ was asked whether an individual has the right to request that their personal information be removed from a search engine. The ECJ held that individuals do in fact have this right where the content is inadequate, irrelevant or no longer relevant. I will be using a variety of research methods in order to aid my final journal piece, including a traditional analysis of cases, statute and existing journal articles and academic comment using Westlaw and Lexis. In a less traditional approach, I have emailed a contact at Google to get a first-hand comment as to how the decision has impacted on Google itself. I wish to add my own generation's opinion to my article, and to do this I will interview my counterparts. More generally, I have emailed the Law Society Gazette to see if I can get some tips on writing an interesting journal piece, and I am gathering statistical data. In terms of legislation, I will be interpreting the Data Protection Directive 95/46 on the protection of individuals with regard to the processing of personal data and on the free movement of such data, and Article 17 of the Commission's draft of the proposed Data Protection Regulation. I have already read a summary of the House of Lords 2014 report called EU Data Protection Law, A Right to be Forgotten. The report considers the consequences of the ECJ's decision and whether the law on data protection continues to achieve a fair balance between the right to privacy, Article 8 of the Human Rights Act 1998, the protection of personal data, Article 16 of the Treaty on the Functioning of the EU, and the freedom to seek accurate information where it is lawfully acquired, Article 19 of the Universal Declaration of Human Rights. The House of Lords believed that global access to personal information has become part of our way of life, and they do not agree with the ECJ's decision. The European Commission and Article 29 Working Party published a further fact sheet in September 2014, in which it tries to counter some of the arguments that were put against the decision. The Commission argues that a sober reading of the article shows that the concerns that have emerged are exaggerated or simply unfounded. I intend to take a narrative approach to my journal article. I would like my journal article to contrast the views of those having to deal with the fallout of the ECJ's decision and those who believe that creating a right to be forgotten will decrease the quality of the internet through censorship and it essentially allows us to rewrite history, and those with opposing views about the problems that search listings for a person's name can create with employment, revenge porn or references to petty crimes if such information were allowed to indefinitely remain an unduly prominent part of a person's footprint.